Hello everyone! Welcome back to our channel. Previously, na-discuss na natin ang item 1, 2, and 3. We are now down to item 4 to understand the concepts of fraud, delay, negligence, and fortuitous event. So our topic for today is about irregularity in performance. I want to start with Article 1170 bago natin balikan si Article 1169. So Article 1170 provides that those who, in the performance of their obligations, are guilty of fraud, negligence, or delay, and those who, in any manner, contravene the tenor thereof, are liable for damages. So as said before, this provision talks about damages. It gives the four grounds for liability which may entitle the injured party to damages. Here, the breach of the obligation is voluntary. Unlike in Article 1174, doon sa fortuitous event, it is involuntary. And just in case you forget, although natalakay natin ito before, damages refers to the sum of money given as a compensation for the injury or harm suffered by the obligee or creditor for the violation of his right. Okay? Sa Tagalog, ito ay danyos. Before we go to the grounds for liability to pay damages, let's just discuss in passing these different kinds of damages. Sa akin, mas naaalala ko to through this mental. M stands for moral. Ito yung mga danyos para sa moral sufferings, ika nga. These include yung mga sleepless nights, besmirched reputation, physical sufferings, mental anguish, serious anxiety, wounded feelings, diba? Social humiliation, yan, and similar injury. E is for exemplary or exemplary damages. Ito yung damages na ini-imposed as a corrective measures or to set an example para hindi siya tularan. N is for nominal damages. This is to vindicate a right. Usually, yung mga nominal, minimal amount lang din. Temporary damages is awarded when the exact amount cannot be determined. When you say actual damages, kung magkano talaga ang actual losses or unrealized profits na gustong i-claim. And L is for liquidated damages. Ito yung damages na nakasulat sa agreement. It is predetermined beforehand by an agreement na in case of breach, magbabayad ng damages and the amount agreed upon by the parties. Nasa kontrata mismo kung magkano ang babayarang damages na if ever may breach of the contract, the parties who will violate their contracts will pay damages. And that is called liquidated damages. Okay? So, yun na yun. Yun yung damages na i-award because of these four grounds. So, let's discuss kung ano-ano nga ba itong mga grounds for damages. So, first, in the enumeration, fraud or dolo. Second, negligence or culpa. Third, delay or mora. And fourth, contravention of the term of an agreement. Now, let's tackle the first ground. Ito ay nabibilang sa mga liabilities na attributable to the debtor or culpable. First, fraud or dolo. In Tagalog, panluloko. Diba? Okay, i-define muna natin what is fraud. Fraud as a ground for damages ay ang sadyang pag-iwas sa obligasyon. It is distinguished from negligence dahil sa pagkakaroon ng sadyang layunin, deliberate intent na umiwas sa obligasyon. Na kung saan, sa negligence ay wala. Okay? Fraud is intentional. Now, what does the law says about fraud? Aside nun sa na-mention siya ni Article 1170, Article 1171 provides that responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. So fraud under Article 1170 and 1171 is more properly called as malice. It should not be confused with the fraud under Article Article 1338, which is more properly called as deceit. So, meron kasing dalawang uri ng fraud sa batas. First is yung fraud in obtaining consent. Ito yung sa Article 1338. Tapos, meron din tayong fraud in performing an obligation, which is, ito yung tinutukoy ni Article 1170 and 71. In Article 1338, yung dun kasi, fraud pre-exist the obligation. Siya yung dahilan kung bakit pumasok sa kontrata ang isang party. Dahil nga, ito ay nangyari lamang dahil sa panlilinglang o panluloko. Hindi sana papasok ang ibang party sa kontrata kung wala yung panluloko. Now, example, fraud under Article 1338 or in obtaining consent. Si Pogi nagbenta kay Ganda ng isang singsing. Nasabi niya ay diamante, diamond ring. Gayunman, ang kwintas ay talagang fake na diamante. The truth is, ito ay yari lang sa isang glass. Yung shining, shimmering glass. Kung alam lang ni Ganda na hindi naman diamante ang kwintas na yon, hindi niya ito bibilhin. So that is deceit. Fraud in obtaining consent. Now, dito naman tayo sa Article 1170 and 71. Nagkaroon na ng obligasyon bago nangyari ang pandaraya, ang panluloko, ang fraud. Example, Pogi promised to deliver to Ganda 100 sacks of rice of a specific variety, yung maganda at mamahaling variety. Upon delivery, dito na sa performance ng obligation, Pogi delivered the rice with that specified variety. Yun naman talaga. Yun nga lang, he mixed it with an inferior variety. Dito, ang right ni Ganda is to claim for damages under Article 1170. Kasi, yung fraud dito is at the performance of his obligation. Okay, so balikan natin yung provision. Sabi, responsibility arising from fraud can be demanded with respect to all kinds of obligations. Later, you will learn that this is not the same in case of responsibility arising from negligence. This is so because fraud is deemed serious and evil. Nang paggawa ng fraud just to avoid the obligation ay talagang dinidiscourage. So, any waiver of an action for future fraud is void. Void, meaning it has no effect. As if walang waiver. And note, future. So, fraud may be past or future. Dito, what is void is the waiver of the future fraud. Waiver of action for the past fraud is valid, okay? Past fraud can be renounced. So, let's move on to negligence. Sa next ground ng liability for damages. Negligence or, sa Tagalog, pagpapabaya. Now, Article 1172 provides that responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts according to the circumstances. So yun nga, ang sinasabi ko kanina, unlike sa fraud, sa negligence, ang korte ay binibigyan ng malawak na discretion in fixing the measure of damages. So, ang dahilan ay dahil ang negligence ay dapat talagang nakabatay sa kalagayan ng bawat particular na sitwasyon. Bukod dito, ang negligence ay hindi kasing lubha ng pandaraya or fraud. Sa negligence, walang bad faith or deliberate intent to cause that injury or damage. But wait, bago natin kalimutan, define muna natin what is negligence. Article 1173, default or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. So, as defined, omission of that diligence. Simply put, negligence ay ang kawalan ng due diligence. The determination of due diligence is always relative, meaning nagdedepende. It will depend on, first, the nature of the obligation. Example, smoking while carrying materials known to be flammable constitute negligence. And another, nagdedepende rin siya sa nature of circumstance. person, diba? Of the person. So kung yung guard natutulog while on duty, he is guilty of negligence. Fine. Ang example dito ay ang pagmamaneho ng kotse na walang headlight sa gabi during nighttime ay negligence. Ngunit, ito ay hindi kapabayaan o hindi naman negligence kung sa araw mo ginawa. Okay? Tapos, place. So, example, yung driving at 60 kilometers per hour on a highway is just normal. Kung malawak ang daan at wala namang mga sasakyan, that is normal. Hindi siya negligence. But, if you do that at the same rate, at the same speed, pero doon mo ginawa sa traffic na lugar, that is negligence. So, there is really no hard and fast rule for measuring degree of care. It is dependent upon the circumstances. Ang hinihingi ng batas ay ang tungkulin ng isang tao to use that degree of care and diligence expected of a prudent and reasonable man under similar circumstances. Inaasahan ng batas ay kung ano ang gagawin ng isang reasonable man sa gayon din or sa kaparehong kalagayan or sitwasyon. So the test of negligence is, did the actor, in doing the alleged negligent act, use the reasonable care and caution which an ordinary prudent person would have used in the same situation? Gayon din ba ang gagawin ng isang ordinary prudent person if ito ay nasa parehong sitwasyon? If the answer is no, then he is guilty of negligence. Tulad ng fraud, negligence results in improper performance, but it is characterized by lack of care, unlike fraud, which is characterized by malice. But note, on the second sentence, when negligence shows bad faith, the provisions of Article 1171 and 2201, paragraph 2 shall apply. So may dalawang uri ng negligence, simple and gross negligence. Ito naman yung sinasabi ng second sentence ng Article 1173. So gross negligence is negligence characterized by want or yung kawalan o kabig mag-ehersisyo kahit bahagyang pangangalaga na not inadvertently but willfully and intentionally. So yung totally wala talagang care na in-exercise. Where the negligence shows bad faith or is gross, that it amounts to malice or wanton attitude on the part of the defendant, the rules on fraud shall apply. So, in gross negligence, same rule shall apply with that of fraud. Kasi nga dito, present na rin yung bad faith. Hindi na lang siya yung ordinary or simple negligence. Now, I would also like to take this opportunity to discuss on the three types of negligence. Culpa achilliana, culpa contractual, and culpa criminal. Yung culpa achilliana or quasi-neglect, actually, na-discuss natin before thoroughly dun sa sources of obligations. Now, if you want to learn or to understand it more, you may refer to that discussion again. Negligence committed independent of a contract without criminal intent. So, si culpa achilliana siya. Tapos, culpa contractual or breach of contract. Dito, the wrong or negligence is in the performance of the contract. Tapos, si culpa criminal or criminal negligence. Ito yung wrong or negligence in the commission of the crime. Example tayo. Taxi driver driving recklessly. Dahil sa reckless na pagdadrive, napatay niya si pedestrian and si passenger. Now, question. What are the sources of obligation of taxi driver and the employer or operator or owner to passenger and pedestrian? So, in answering this question, we have to differentiate. Iba si pedestrian and iba si passenger. So, as to pedestrian, the right of the heirs, syempre yung mga heirs na yung magkiklaim kasi namatay na si pedestrian. The right of the heirs is to proceed against taxi driver and employer, and this is based on culpa achilliana or quasi-delict. Why? Because there is no pre-existing contract. So, culpa achilliana. Tapos, as to passenger, the heirs of passenger is to proceed against employer or the operator. And the source of liability is culpa contractual or breach of contract. Why? Because Dito, meron tayong tinatawag na contract of carriage with the passenger and the operator. The case should be filed against the operator because the contract is actually between the passenger and the owner na sinasabi ni operator, dadalhin kita ng safe doon sa destination mo. Now, let's proceed to the third grounds for liability of damages, delay, which is natalakay natin in passing during the second part ng discussion sa nature and effects of obligation. Now, if you haven't watched it, I highly encourage you to watch it also. Okay? Medyo mahaba tong Article 1169, pero unahin natin itong general rule, yung first paragraph. Those obliged to deliver or to do something incur in delay from the time the obligee judicially or extrajudicially demands from the fulfillment of their obligation. So, as previously said, delay has nothing to do with quality, but only with punctuality. Delay is the non-fulfillment of the obligation with respect to time. In fraud and negligence, the question is the quality of the performance, even if performed on time. In delay, even if the quality is excellent, but the performance is not in due time, the debtor is liable. Okay, that's it. Now, accordingly, there are three kinds of delay or legal delay. We're referring to legal delay. Now, three kinds of delay: mora solvendi, ito yung delay on the part of the obligor; mora accipiendi, or delay on the part of the creditor; and compensation more, or both parties are in delay, both parties defaulted. Sa mora accipiendi, creditors incurs in delay when the debtor tenders payment or performance. Ngunit, si obligee or si creditor, tumatangging tanggapin ng walang dahilan ang performance or ang payment ni debtor. Plus, i-insert na rin natin tong effects of mora solvendi or mora accipiendi. Sa mora solvendi, the creditor may ask for damages. Tapos, the debtor is liable even if the loss is due to fortuitous event. This is actually consistent with Article 1165, diba? Kahit may fortuitous event, magiging liable pa rin dahil meron ng delay. Tapos, third, the debtor shall bear the risk of loss. Okay? Tapos, sa mora accipiendi naman, si creditor na yung mag-bear the risk kasi siya yung, syempre, defaulted. So, debtor now is exempted from the risk of loss. Dahil automatic, napasa na siya kay creditor. Si creditor na ngayon yung nagbe-bear ng risk. Tapos, expenses incurred by debtor for the preservation of the thing after the delay shall be charged to the creditor. So, yung mga gastos ni debtor para pangalagaan at i-preserve yung bagay na binibigay niya pero ayaw tanggapin ni creditor, charge yun dapat kay creditor. Tapos, if the obligation has interest, hindi na magiging liable pa si debtor to pay that interest from the time na nag-delay si or na-default si creditor. Tapos, another is, sa lahat naman talaga ng breach of obligation, the defaulting party is liable for damages. Now, yung effect naman ay compensation more. Dito, kasi nga both sides yung in default, the net results is that there is no actionable default on the part of both parties, such that as if neither one is guilty of delay. So, meaning, like as if walang na-delay or na-default sa kanila kasi pareho naman sila. Pareho silang default according to the law, like as if walang delay. Until such time na yung isa is already nang i-comply yung kanyang obligation. So, question, in an obligations to give or to do, when does the obligor or debtor incur in delay? Malinaw sa Article 1169, it is from the time the obligee the judicially or extrajudicially demands the fulfillment of their obligation. And despite that demand, the debtor or obligor is unable to comply with his obligation. So kapag nag-demand na, other party ay hindi makapag-comply, he is now in delay or default. Therefore, the mere expiration of the period fixed is not enough in order for the debtor to incur delay. There must be demand and then non-compliance. So just keep in mind, no demand, no delay. So either judicially or extrajudicially. Judicially, filing of case in court. Extrajudicially, sending off the demand letter to the debtor. So again, ganito lang. General rule, demand is necessary. And please note, demand is not a mere reminder or notice. Hindi ito yung nire-remind mo lang sa utang. Dapat demand talaga to pay. So example, Pogi obliged himself to deliver to Ganda a specific car on December 25. If Pogi does not deliver the car on December 25, he is only in ordinary delay, absence any demand from Ganda. Okay? Kung walang demand, kahit na dumating pa yung December 25, hindi pa in delay, ordinary delay lang siya. Pero as to in the eyes of law, hindi pa siya defaulted. The law presumes that Ganda is giving Pogi an extension of time within which to deliver the car. Okay? So, sa makatwid, walang paglabag ng obligasyon. At si Pogi ay hindi pa mananagot for damages. Now, if a demand is made upon Pogi by Ganda on December 28 and Pogi fails to deliver the car, so Pogi is considered in default or in delay only from that date. So after the demand and no compliance was made by Pogi, dun pa lang may delay or in default na si obligor. However, the rule is not absolute. Obviously, mahaba tong provision na to. So, subsequent paragraph in Article 1169 provides for exceptions, meaning, kahit na walang demand, di ba? No demand, no delay. Eto, walang demand, pero may legal delay. Okay? Sabi nga, when the obligation or the law expressly so declares. Okay, dito dapat lang talaga, dapat express stipulation talaga na hindi na kailangan ng demand either sa batas or sa kontrata mismo na may automatic delay without need for demand. On the same example, Pogi obliged himself to deliver to Ganda a specific car on December 25 without the need of demand. Hence, if on December 25, Pogi does not deliver, the next day, he is already considered in default or in delay. Okay? Kasi nasa kontrata na, he will give a specific car on December 25 without the need of demand. Now, let it be noted that ito ay hindi sapat na nakafix na yung date ng pagko-comply sa obligation. Okay? Ang tinutukoy ko lang talaga dito is it must be expressly stated. Dapat talaga hayagang nakasulat or nakalagay sa kontrata or sa mismong batas that there is no need for demand. Now, example sa batas, ang pinakamagandang halimbawa dito ay ang pagbabayad ng tax. So, taxes should be paid on or before this specific date, di ba? Depende kung anong tax. May deadline yan kung kailan dapat bayaran. Otherwise, pag hindi ka nagbayad, makaka-incur ka ng mga penalties. At hindi na kailangan na mag-demand pa ng gobyerno para magbayad ka ng tax at that deadline. Okay? Next. When from the nature and the circumstances of the obligation, it appears that the designation of the time when the thing is to be delivered or the service is to be rendered was a controlling motive for the establishment of the contract. Okay? Dito, ang mahalagang linya ay itong, it appears that the designation of time was a controlling motive for the establishment of the contract. Simply stated, when time is of the essence of the contract. Example, yung mga wedding gown, wedding cake, ito ay dapat handa at tapos na bago pa ang kasal. Demand is not needed here. Okay? Pagdating ng araw ng kasal, walang wedding gown na may susuot si bride dahil hindi nakapag-deliver. So, automatic in default na yan. Obviously, no need for demand. Okay? Yun lang yun. Time is of the essence. Tapos lastly, when the demand would be useless, as when the obligor has rendered it beyond his power to perform. So, useless nang mag-demand kasi kahit na mag-demand pa, it is now beyond the debtor or obligor's power to perform. Wala na siyang control o kakayahan na ma-fulfill pa ang obligation niya. The best example, Pogi sold his only car to Beauty, when in fact, nabenta niya na rin naman yan before or previously kay Ganda. Hindi kailangang mag-demand ni Ganda kay Pogi to deliver the car, since demand would be useless. In case of reciprocal obligations, the performance of one is conditioned upon the simultaneous fulfillment on the part of the other. So neither party incurs in delay if both does not comply or is not ready to comply in a proper manner with what is incumbent upon him. Example, Pogi sold to Ganda a specific car for 1 million pesos. Both agreed that delivery and payment shall take place on December 25. However, kung sa December 25, parehong si Ganda ay hindi na makakapagbayad at si Pogi ay hindi pa makakapag-deliver ng sasakyan, then it's like as if walang delay or defaulted sa kanila. Okay? Hope malinaw na. So let's proceed to a regularity of performance but is not attributable to the parties like Article 1174. Ito yung mga non-culpable. Except in cases expressly specified by law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk. No person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. Okay? Fortuitous event. Tulad ng tinalakay dati, ito ay anumang hindi pangkaraniwang kaganapan na hindi maaaring nakinita, or kung makikinita or nakikinita man, ay hindi naman maiiwasan. So, ang kahulugan ng fortuitous event is actually so broad enough so comprehend acts of God or those which are absolutely independent of human intervention such as rains, typhoons, floods, earthquakes, ano pa ba? Iba pang mga katulad na kalamidad na dulot ng kalikasan. Then, it is also broad enough to include force majeure or yung mga kaganapan na nagmumula sa lehitimong gawa ng mga tao maliban sa obligor, of course. So, tulad ng digmaan or mga robbery. So, kapag hindi nagawa ng debtor or ng obligor ang kanyang obligasyon dahil sa fortuitous event, his obligation to comply is extinguished. Mawawala and without any liability. Okay? So, that is the general rule. Pero meron din siyang mga exceptions. So, ito yung tatalakayin natin, di ba nga, except in cases expressly specified by law. So, ano ba to? Yung natalakay natin under Article 1165, pag may delay, or yung nag-promise siya to two or more persons who do not have the same interest in isang bagay, di ba? Tinangako niya sa dalawang magkaibang tao. Accordingly din sa Article 1268, pag ang death of a thing certain and determinate proceeds from a criminal offense. Tapos, meron din sa 1263, pag ang bagay ay generic. Kasi nga, pag generic naman, the debtor can still comply with his obligations by delivering another thing. So, nawala yung kotse. Hindi naman specific kung anong kotse. Di magbibigay siya ng ganong kotse pa rin. Yung, ano lang talaga sa fortuitous event is yung mga specific thing. Like yung one and only car ni Pogi. Nawala. So, wala na. Kasi yung promise na yung one and only car lang naman niya yung ibibigay niya. Okay? Mga ganun. Tapos, yung next, when expressly declared by stipulation or by contract. Kasi, ang basis dito for this exception is actually the freedom to contract. Okay? Yung mga parties ng contract, sa pamamagitan ng stipulation or kontrata, ay maaaring palawakin or higpitan ang fortuitous event. So, in certain cases, sabi nga ng Supreme Court, the contract may provide for a stipulation imposing liability even in cases of fortuitous events, and the same shall be binding upon the parties. Tapos yung third, when the nature of the obligation requires the assumption of risk. This is known as the doctrine of assumption of risk. Ito ay tumutukoy sa isang sitwasyon kung saan ang obligor ay may ganap na kaalaman sa risk na involved. Okay? Tapos, voluntarily, he assumes such risk. Okay? So, this is based on the principle, no wrong is done to one who consents. So, this is best illustrated in insurance contracts. Okay? Now, Kompletohin na rin natin yung discussion. Sama na rin natin yung ibang provisions under the chapter on nature and effects of obligations. Para sa next video, we will be discussing the different kinds of obligations na. Okay? Medyo mahaba din yun. So, proceed tayo. Article 1175, usurious transactions shall be governed by special laws. So, ito yung mga interest in exist of the amount allowed by law for the loan or use of money. Article 1175 simply says that they are governed by special law, like the usury law. Now, actually, class, Article 1175 is a dead letter law because of the lifting of the ceiling on the interest rates. As of now, so long as nag-agree yung both parties for that interest, wala nang maximum rate. The usury law has been decriminalized. So, some decisions have been struck down with high interest, not because they are usurious, but because the rates were unconscionable. Now, Article 1176, the receipt of that principal by the creditor, without reservation with respect to the interest, shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt without reservations as to prior installments shall likewise raise the presumption that such installments have been paid. So, Article 1176 provides for two presumptions regarding interest-bearing debt at yung sa debt payable in installments. Okay? So, accordingly, nagbayad, in-apply mo directly to the principal. Meaning, pinipresume na bayad na yung interest. Kasi diba, as a rule, dapat naman talaga, ang unang bayaran is yung interest bago yung principal. Tapos, yung sa debt payable in installments, ang presumption naman is, ang mas naunang installments ay bayad na rin kung nagbayad siya at in-apply mo na sa yung mas huling installment at tinanggap yun ni creditor without reservation tungkol sa nakaraang installments. Okay? Okay, so example tayo dito. Pogi borrowed from Ganda 10,000 pesos at 12% interest per annum. So on the date of maturity, nagbayad si Pogi kay Ganda. At si Ganda ay nag-issue ng resibo with the following tenor. Sabi, receive from Pogi 10,000 pesos in payment of his obligations. Signed, Ganda. Ang tanong, is the interest paid? So, dito, ang presumption is, bayad na yung 12% interest. Ang pagbabayad ay ina-apply naman talaga muna sa interest bago yung principal obligation. Dito, in-apply niya na may principal obligation, tapos hindi pa siya naglagay ng reservation as to the interest. So, kung hindi pa talaga bayad ang interest, dapat nilagyan ni Ganda ng ganito. Receive from Pogi 10,000 pesos in payment of his obligation, interest unpaid. Okay? Now, another example. Pogi sold Ganda a specific car for 10,000 pesos payable in 4 equal installments. Okay? Equal installments. Tapos sabi, January 1, 25,000. February 1, 25,000. March 1, 25,000. And April 1, another 25,000. Now, if Ganda, nagbayad siya ng first and second installments. Tapos yung third, noong March 1, di siya nagbayad. Then, on April 1, nagbayad ulit siya. So, what is the right of Pogi? So, dapat, gawin ni Pogi, i-apply niya yun sa third installments. Now, kung gusto niya i-apply sa fourth installment, dapat maglagay siya ng reservation na the third installment is not yet paid. Anyway, these are just rebuttable presumptions. So, meaning, maaari mo namang patunayan sa pamamagitan ng iba pang mga katibayan kung ano ba talaga yung nangyari or yung mga pagkakamali mo. Okay? So, Article 1177. Okay? So, simplify na natin. These provisions actually discuss on the remedies available to the creditors for the satisfaction of their claims. Number 1, mag-demand ng fulfillment ng obligation with right to damages. Tapos, second, pwede rin i-exhaust ang property ni debtor through attachment. Third, action subrogatoria. So, ito naman yung action where the creditor whose claims had not been fully satisfied may go after the debtors. Yung sa mga third person of the debtor. You are put into the shoes of that debtor to claim for payment dun naman sa mga may utang sa kanya. So, yun yung action subrogatoria, or the right to be subrogated. Ito is premised on the theory that the debtor of my debtor is my debtor. Ang may utang sa akin ay may utang rin sa akin. Parang ganun, okay? So, number 4, action Pauliana. So, an action where the creditor files an action in court for the rescission of acts or contracts entered into by the debtor designed to defraud the former. Upang hilingin sa korte ang rescission ng kontrata na naglalayong mandaya sa kanya, this is action Pauliana. Okay? Note, ang action subrogatoria and Pauliana are subsidiary to yung sa mga naunang rights available sa kay creditor. So, hindi pwedeng uunahin niya na kaagad to. Dapat yung mag-demand muna siya, tapos i-attach niya, tapos kung wala talaga, subrogation. So, to better understand this whole concept, let's take the example from the Book of De Leon. Ito yung sa kanya. On the due date, D could not pay C his obligation in the amount of 300,000 pesos. However, D owns a car worth about 160,000 pesos and X is indebted to him for 40,000 pesos. Before the due date of the obligation, D sold his land worth 200,000 pesos to Y. Okay, ganito. Kunin natin yung mga relevant facts. Si D ay may utang na 300,000 kay C at hindi niya na kayang bayaran. 300,000 loan. Pero, ito yung meron siya. A car worth 160,000. Tapos, may utang rin sa kanya si X na 40,000 pesos. And, bago pa man yung time na magbabayad na sana siya kay C, binenta niya yung lupa niya kay Y na worth 200,000 pesos. Okay? So, applying our previous discussion, under the circumstances, the rights granted to C are as follows. Una, he may bring an action for the collection of amount of 300,000 pesos with the right to damages. Now, kasi nga wala na rin naman talagang pera, hindi niya kayang bayaran, ang susunod na gagawin, if hindi talaga nakapagbayad si D. So, C can ask for attachment of this car. So, yung car niya ngayon is i-attach. So, yung car ay ibebenta, tapos yung proceeds ng sale ay ibabayad sa kanya. Okay? Now, di ba nga yung car is worth 160,000, is 300,000 yung utang, kulang pa ng 140,000. Eto pa, si X ay may utang sa kanya kay D. He may ask the court to order X not to pay D so that payment may be made to C. So, third, ito, he may ask the court to order X, yung may utang kay D na yung bayad is wag nang ibigay kay D, diretso na kay C. Pero yung court yung magde-decide nun, ha? He may ask the court for this, that is action subrogatoria, para ma-claim niya yung 40,000 pesos na utang ni X. So, 40,000 na. 160 plus 40,000, 200 is 300,000 yung utang. So, pwede pa. Ang last na pwede niyang gawin is he may ask the court to rescind or cancel the sale made by D to Y. So, yung pagbibenta ni D ng lupa kay Y, it appears na yung pagbibenta niya is actually more on to defraud C para hindi makuha yung lupa, di ba? So, yun yung ground niya. Pero dito, yung makukuha niya na lang is yung remaining 100,000 pesos kasi nakuha niya na yung car worth 160, tapos yung utang kay X na 40, so 200. 300 yung utang niya. Note, again, this last remedy can be resorted to only if C could not collect his full credit. Tapos, he must first exhaust the properties of the debtor or subrogate himself in the latter's transmissible rights and actions. So that's Article 1177. Now, the last provisions, Article 1178. Subject to the laws, all rights acquired in virtue of an obligation are transmissible if there are no stipulations to the contrary. So, as a rule, all rights acquired in virtue of an obligation are generally transmissible, meaning pwedeng napapasa. Pero, general rule, yung exception dyan, number 1, not transmissible by nature, like purely personal. Second, by provisions of law, hindi daw siya transmissible. Tapos third, kung by stipulation na naman ulit. Stipulation of the parties. So, that's it. Thank you for watching. If you want to see more, please like and subscribe and click that bell button para updated ka sa next video na upload namin. Likes and subscriptions is actually worth so much more. Ito yung nagsasabi sa amin na this is worth it pa. Okay? Thank you.